such as it is. Okay, Brynolson,
Here.
Hamilton.
Present.
Okay, and I'm going to share a PowerPoint presentation that gathered all the information that we had talked about, and we have Ron B on the line because one of the big pieces of information was about the bar exam pass rates for the different types of schools. So let me just go ahead and share this. So can you see that? Are you able to see the PowerPoint?
No.
No.
Huh, I wonder why not. Hold on a second. Oh, one last step.
Now I can.
Yep.
Okay, great. All right, so, well, wait a minute. Yeah, so these were the recommendations, your sort of the preliminary recommendations that we brought to the meeting of the full working group on the 29th. So I don't know if you want to go through them, but there was the educational requirements, the JD from the ABA or California accredited school, or a paralegal certification, the educational requirements, the practical training, the testing, the moral character and background check. And then we got a lot of feedback during that meeting. And based on that, we, I think what was agreed was that you'd go back and consider some of the questions based on the feedback. So here are the considerations. And if I didn't accurately capture it, you can let me know. But the first question is, should graduates from other law schools, the unaccredited law schools, qualify for admission to the program? And also whether graduates with different types of degrees, so LLMs and actually, this is a typo. It should say MSL, not MLS. Sorry. It should say MSL is what the program calls it. I'll fix that. And then there was a question about the experiential hours that are required, and then putting sort of defining requirements for supervision for the attorneys providing the supervision. So is there anything else besides these things that we wanted to revisit?
I think it may. I think we maybe were talking a little bit about. Is that me giving the feedback?
Yeah, I'm hearing it from you.
Okay, let me try again. Is it bad? Okay,
No,
I think we were going to talk about also, was there anything else that we could specify about the training hours at this point? And I had some thoughts about that, but I think we should just start from the beginning of the list.
Okay. Oh, and actually, before we get started, I neglected to do a call for public comment.
Okay.
So let me just stop sharing for a moment so that I can see. Oh, actually, maybe I can see the participants and see if there's any attendees who wanted to make public comment. I see we have about, it looks like 8 attendees. Is there anyone who wants to make public comment? If so, you can raise your hand using the button in the bottom center of your screen to raise your hand. We did get written public comment that I sent to you on Friday. That came from Hastings. Okay, we have one person who has requested to talk. So I'm going to go ahead and start that. So Charlie Gillig.
Hi. Hey, thanks, Linda. And I actually don't have a comment specifically now on the substance, but I have a request if we could have a brief period at near the end for public comment, sort of to maybe comment on the discussion today. Would that be possible?
Sure, if we want to have the public comment at the end, the issue though is it just we'll have to make sure that we set aside some time. So we can set aside 10 minutes or so.
I would appreciate that. I think
the
it would
end
be
of the meeting.
beneficial.
Is that okay with you, Julia and Stephen?
Yeah.
Yeah, no
Okay.
objection as long as we've covered the substantive issues before then.
Okay. Come back to public comment at the end of the meeting. Okay, so then I'm going to go back to the slideshow. So the first topic then is this comparison of bar exam performance by law school type. And Ron B was once again used his analytical expertise and the access to information to do some analysis. And so I'll ask Ron to explain the information and answer any questions that you might have. So Ron, you're on.
Okay, so you all go through the slides as I talk?
Yes,
Okay,
you can let me know when to advance.
so the first slide just presents the data that I pulled together in order to answer the question. The question being, looking at the bar exam performance over the past 5 years, or whatever sample size we wanted to look at, in order to see whether there are any differences, statistically significant or in terms of size that's significant across different school types. So from here, over 5 years, you can see we pulled applicants who took the bar exam from ABA law schools in California, as well as out of state. And then another 2 major groups for comparison is California accredited and registered. The sample size is large enough, so whatever difference that we see, we can put in with confidence, say what's going on. And the number of school is also an important factor. It's also, we have quite a few for a meaningful comparison. And the overall pass rate, you can see the 4 categories are significant difference between ABA and out-of-state ABA, and certainly between these 2 compared to the other Cal accredited and registered. But between Cal accredited and registered, pass rate, there's hardly any difference, and also very small difference in comparison of the total scale score based on median. So move on to the next slide, where try to look at it from different perspectives. Can you move to slide 2? This is just the pass rate in the same results that we just looked at it in tabular form on the first slide, and just to accentuate the difference between the 4 schools, 4 school types. Next. A median score, you don't see as stark a difference. It's simply the artifact of what we're looking at. The median score between ABA and out-of-state ABA, whatever comparison we're making, it's important to remember the spread of the total score. 1 standard deviation historically is about 150 points. So when we see this difference between ABA, California, and out of state, statistically it's significant. Even the small difference between Cal accredited and registered, statistically it's a significant difference of just the 10 points. But then in terms of the size between the 2 pairs, I don't think you can say it's meaningfully large enough difference. And a different way of looking at it is to break it out by individual schools and see what the patterns show when you look into a little more granular details. So that's what we'll see next few slides. And this is the distribution pattern. It's called the box whisker plot. It's very useful to show where the scores are clustered. So the box represents the middle 50% of the distribution, and the whisker represents what's typically considered an outlier, the edge of that distribution. And it shows between, again, ABA in California and out of state, the middle 50%, you can clearly see the difference. Out of state ABA is slightly lower than California ABA. And you hardly see any difference between Cal accredited and the registered school. In this view, it again confirmed what we looked at in both the tabular form on the first slides and in some other forms in the previous slides. Next, please. Now here it's breaking up by school. Since we saw no statistically significant difference that's large enough across all of the individual exam takers between Cal accredited and registered, it'll be interesting to see by individual schools, what is the pattern of the distribution. Here, you can see there's a few Cal accredited schools with higher pass rate, as well as something that's correlated at the median total score, away from most of the other law schools in either type. Aside from those four to the right of the distribution, with near 30% pass rate and median scores over 1350, the rest of them are clustered together. In other words, Cal accredited and registered in terms of individual law schools, we don't see as clear a difference as what we saw in between, say, ABA California and out-of-state ABA schools. So whatever the difference that we see between individual applicants is the result also of this mixture of different law schools with different performance levels. And the next one is similar comparison between California ABA and out-of-state ABA. Here, you see the pattern of California ABA, over 20, all of them over 20% pass rate, and then a small cluster of out of state below that level. But otherwise, it's a similar kind of a mixture together across the entire distribution. I think that's it. Is there any other? Yeah, and here is the last one for comparison between different schools where the applicants took the first year law school. The majority are from California registered law schools, and I don't think there is meaningful comparison across the different school types. Mainly it's just to show the results over the past few years. Pass rate for first year law school is about 20%.
The 6.4% rate for the California accredited, that's a pretty significant marker compared to the pass rate for the other three, right? Statistically.
Yes, if you want to compare the difference, certainly that's a significant difference. But the applicants who take the first year law school, in terms of requirements, my understanding it's largely, if not exclusively, Cal registered schools. And for those few who took the first year law school coming from either ABA, those 91, or 235 from Cal accredited, they must have something else going on where the profile or the performance level is so different, then I don't think they can be easily compared fairly with Cal registered schools. I don't understand exactly what's the different requirements for other than Cal registered schools. But here I'm just pulling all the data together where students have taken the first year exam.
And that's why the bullet points at the bottom of the slide explain who's required. So as Ron said, it's a very small number of people that are other than those who are at California registered law school that have to take the first year exam. Sometimes a school will admit someone on the condition that they pass the exam in order to continue. And then again, if someone is admitted, and the last two might have a lot of overlap. So people who are admitted to law school without having first gotten their undergraduate degree, that's probably a significant number of those people who are conditionally approved. I imagine that's a similar subset.
It was interesting. We didn't know this before pulling this data together for you. That it was all these different folks that potentially have to take the baby bar.
Right. And the study in law officer judges chambers, it's just a couple of people a year at most, I think. Isn't that what you found, Ron? It's not.
Yes. So going back to the original purpose of looking at this, if it's related to the decision of whether to grant this paraprofessional for applicants from one school type versus the other, the result shows certainly there's significance between CalAccredit and registered together in comparison with ABA, whether California or out of state ABA. But between registered and CalAccredit, the data shows there's no meaningful systematic difference between applicants coming from these two school types.
Yeah, there's no statistic. That was clear from the first one. So Linda, I think this slide and the two that preceded it that Ron compiled should make their way into our next general meeting when we have the discussion about the licensure, because we need to share these statistics. These are definitely not what I expected. I mean, if anything, it shows that the slide that's up right now shows that the unaccredited schools are getting a better pass rate on the first year or the first year law school exam over the accredited schools. Again, it's the small number that might be skewing that percentage, but the fact is it's the opposite of what I expected.
So Stephen, are you saying that you now maybe would be willing to consider allowing graduates from the registered schools to participate, just as we discussed with the accredited?
I'm open to it now. I think here's one of my biggest concerns, Julia, is new schools popping up, new schools being created, and people being told, hey, we can turn you into a paraprofessional. I don't want to reference any trade schools or other type of non-conventional schools that have gone failed recently, but we've seen that where we've had these trade schools that lure people in and get them to get loans and pay it. So I'm wondering if we could put a criteria that, you know, it could apply they can be a graduate from a registered law school so long as that law school has been in existence for X number of years. Is that a criteria that we could put in, Leah?
I'm sure you could put in whatever criteria you want to.
Stephen, the only thing I'd say is, you know, again, in my experience of teaching, it's I'm not as concerned about having trade schools pop up because they have, I mean, at the end of the day, the students have to be successful in the program, and we can maybe talk about how they would have to be permitted to teach a particular curriculum at an institution and address it that way instead of, you know, the existence,
Right.
You know.
That was my first thought. And I'm not saying this from a paraprofessional standpoint. I'm saying this from a consumer standpoint. I'm worried about people being taken advantage of.
Well, a
registered school though is registered by the state bar, and they can't, you know, you can't just like hang a shingle out and call yourself a registered school. So I don't have the specifics like in my head right now, but I think there are some protections because you do have to go through some steps to become registered. So I don't know if that alleviates some of your concerns, Stephen. Certainly we could bring that information forward, but there, you know, I can't just decide I'm going to be a registered law school tomorrow.
Right. And I think And I think that when we're comparing law schools to trade schools, I think there's a significant difference. People were preparing students in trades that later couldn't get jobs or pass licensing tests. That is, in my opinion, somewhat different than what we're doing here.
Okay.
And also, if I'm not mistaken, this is Araya, good morning. I think that the bar's Office of Admissions also regulates the schools where there is always an oversight. They go and audit, and so it's not like they're just accredited and then left on their own. There is an oversight from the bar.
Yep.
Can we go back? We have a slide that tells us the total number of test takers from the registered law schools. Okay, so this means over a 5-year period, there were a total of 2,865 test takers from the registered schools. Am I reading that right, Mr. Pai?
Oh, that's correct.
Okay, and
Remember those, they also, the numbers also include repeaters.
oh, okay. And of those test takers, 14.5% pass. And some of them would probably keep retesting too, I would assume. So really, we're talking about over a 5-year period. I'm going to double the pass rate and assume some of them are going to stay committed to being lawyers. Really, we're only talking about a population over 5 years, cumulatively over 5 years of what, maybe 1,500 that are graduates that never passed the graduates of California registered schools that didn't pass the exam within a 5-year period.
It's close, but then in order to answer the question about unique individuals, I have to pull the data separately, because the proportion of repeat takers vary significantly across the school types also.
Okay. Do we have statistics on how many graduates? We're kind of, I get your point. That 2,865 could include somebody who took the test all 5 years and took it twice each year.
Right, that's right.
Do we know how many graduates there are of the California registered law schools over the same 5-year period?
What can I ask, Stephen, what do you think this is going to show us?
I think that there's going to be some that are going to have a knee-jerk reaction like I initially did. Well, we can't include the unaccredited or the registered law schools. And if we show that it's a really small population that we're talking about anyway, that we shouldn't be as worried about it.
Yeah, I think this has been sufficient for me not to be concerned. I say they can do it.
So, but that's why I wanted that question answered, because I want to be, I'm thinking to the general meeting and the discussion that's going to ensue, because I know I can reasonably infer and assume that there's going to be some that are still opposed to it that weren't privy to this presentation. Do we have any idea what the total number of, how would we get the number of graduates from the accredited law schools over this time period? Or do we have it?
I'm looking at it now. It's about graduate eliminating repeat takers for this period is 1,127 registered.
1127. So 200, 125.
But
No, it's about 225.
You're confusing me a little bit when you're talking about eliminating repeat takers. Are you including people who graduated who may have never taken even one bar exam?
No.
Yeah,
This
so
this is right.
I think we can get the information, Stephen, because not everybody takes the bar. But the point is, it's not very many.
That's what I was kind of trying to get to. It's like,
Yeah.
I don't want, when the chicken littles come out and say the sky is falling if we allow California registered law school graduates to take the test, I want to put a number on it and throw it out that, look, we're only talking about X number of individuals who are still going to have to meet the criteria of our paraprofessional program. We're still going to have to pass the test. We're still going to have to do the experiential.
And we can certainly include data from this slideshow in the body of the memo
Yeah.
that goes to the working group.
Yeah.
Yeah, and we'll get the graduate number.
Yeah, I would have that out there just to show we're not going to be flooding the paraprofessional program with all of these thousands of California registered law school graduates. It's really a small overall number that we're talking about.
Yes.
And I think that will help to be persuasive that it's not as significant a risk as some people think it is. Because I thought it was, my knee jerk was, why would we do that? And now after looking at these statistics, why wouldn't we? Because there's no statistical difference. If anything, the California registered students are doing better statistically on the first year exam. And on the bar pass rates, there's the statistically insignificant difference between their bar pass rates between accredited and registered.
Right.
Yeah. So yes, Julia, I'm on board.
Okay.
I didn't think I would be, but I am. See how persuasive you are? Actually, it's Mr. Pai's charts. That's what was the convincing.
The data is powerful.
Yes.
Yeah.
I'm a big believer in that. My undergraduate degree was from resource economics at Cal. So I'm a big believer in stats.
All right. Thanks, Ron.
Thank
You're
you
welcome.
very much,
Thank you
Ron.
very much. It was really helpful.
Bye.
So the next question we wanted to consider was the different types of law degrees other than JD. So the next few slides provide information about those requirements. So these are the JD requirements if you want to take a minute, and I'll certainly make this slideshow available. I'll put it in the Dropbox and I can also send it to you directly.
Okay, that would be helpful.
Yeah, so, and what you can see is that in terms of the practical skills, because I think that was a big part of the focus of the discussion, the California the accreditation does not, it requires the schools to offer an opportunity for practice-based skills and competency training, but it doesn't require the students to complete anything in order to graduate. The ABA approved schools do require that students have 6 credit hours in practical skills. And practical skills isn't necessarily in a, it doesn't have to be in like a clinic or in an externship. It can be a simulation course. And I had some conversations with people at a couple of law schools, and I think that there's a strong belief that these simulation courses are quite effective. So they all require professional responsibility. There's writing. The ABA specifies that you have to have a writing experience in your first year and then at least one additional writing experience in a subsequent year. The California accredited, it includes writing in the practical skills training. Again, it's not required. It's required for the school to offer it. So, do you have any questions about this slide?
I have a question, Linda, just because I'm always struggling to compare. The 270 hours of classroom attendance per year for the registered,
Right.
is that equivalent to academic engagement hours?
Yes. Yes.
Okay. All right. So it would be comparable to the 15 hours of academic engagement, equivalent to 1 unit in the California accredited environment.
Right. So the hours included in a unit assumes that you're spending 2 hours outside the class actually doing work for each 1 hour you spend in the classroom.
So
and just so Stephen and Julia understand, that requirement comes from Rule of Court 9.30. So that 9.30 sets forth some minimum requirements for registered law schools, because it wasn't, there weren't standards put forth in the State Bar Act. So the court stepped in and imposed those requirements.
So the total number of hours is slightly lower than for the California registered. I'm calculating it being 120 less or 30 hours less a year.
yeah, that's what I get to.
Yeah. Okay. Yeah. I will say this, Julia, even if they've got given what we heard and the feedback we got on the experiential, even though that we're seeing this, I don't think, this doesn't change my position, revised position on accredited versus registered. And it doesn't change my position about upping the experiential. I think, especially when we see that for the accredited and registered, that the opportunity is there, but there's no requirement. I know the ABA schools maybe would want to get some kind of credit against their experiential because they have to take 6 credit hours, but I think having a uniform standard will be easier to administer.
So in conclusion, you're saying this doesn't affect what part of our plan?
I would look at this slide as being information that would affect the experiential potentially. And I'm saying it has no impact on my revised view on the experiential and what we should do with it.
And where are we with our revised view? Did we go to 1,000?
Well, we haven't got there yet, but that's what
Okay.
that's what I want to go to.
Yeah. All right.
So this slide shows the LLM requirements, and that for the LLM, there's always that the person enrolled in an LLM program has to already have a first degree in law. So for U.S. students, it's usually if they have their JD and they want to specialize in a particular area of law. The majority of people in LLM programs have their first degree in law from another country, and they enter an LLM program to qualify to take the California bar exam. And so for the US students, this is allowing LLM is not going to have any impact because they already have their JD. The question is whether students from other countries who have a law degree from their country and then get an LLM from a California or ABA accredited law school outside of California should be admitted. And as the memo from the public comment from Hastings that we got, and previous to the October 29th meeting of the full working group, we all got public comment from McGeorge. Their argument is that the LLM and also their MSL is a higher standard of education than the paralegal education, and so they believe that the LLM should be allowed.
Well,
I wanted to say one more thing. We didn't have this on the slide for the baby bar. I don't know, Linda, if you caught this email that we got from the director of admissions, came in late one evening. And Julia, this goes to a point you've made previously. It says foreign attorneys with a law degree that is not considered a first degree in law also have to take the baby bar. A first degree in law refers to the fact that the law is based on the common law. So if they've got a first degree in law, that means they're coming from a common law country. Students with law degrees from Egypt, for example, must take the baby bar. So those are LLM students. So I thought, Julie, that was relevant to a point you've made, and I wanted to make sure to share that.
Yeah, I didn't know that before, that it had to be a common law jurisdiction.
These are all ABA accredited schools. Are there any registered schools or California accredited schools that are offering LLM or MS programs?
I don't know. That's a good question.
Because I guess looking at these requirements, I mean, I wouldn't have an issue with an LLM graduate being qualified to become a paraprofessional based on this information, but I'm wondering if we should restrict the LLMs and MS to graduates from an ABA accredited school.
I would, there probably is not an LLM at non-ABA. It's hard to establish this program, but I've never looked at it specifically, but what I have no problem with now that I heard that from Leah about the LLMs, My concern was more with the master's program, because it sounded like when I looked at the Hastings letter that they've only had 1 year and 1 year only of real legal education. It didn't seem like, and it was it seemed to me anyway, that the curriculum was pretty theoretical and not very practical. So I
The
think,
next slide, if you want, I can show the next slide that has the MSL requirements.
okay, let's take a look at that. Yeah.
Oh, I am seeing California, at least accredited schools that do have an LLL program. They had Jefferson down in San Diego. Whittier doesn't exist anymore.
So here's the Masters of Studies in Law. I think you're right, Julie. It was my impression too, looking at this. It's truly like a master's program, not necessarily geared in any way towards someone who's going to practice law.
Exactly. At this point, seeing this was very helpful, and the letter from Hastings describing the curriculum also helped me. I, at this point, think that the LLM students would be fine as candidates, but the MSL just doesn't seem like they've had enough.
I don't know if you can. Go ahead. I'm sorry, Joe.
Huh?
I was just going to say, just so you know, I'm not copying you. If you can see my little post-it, I had LLM yes, MSL no.
Okay, so we seem to be on the same page with this one. But I mean, you know, what's interesting to see is if they do, you know, are able to get through a paralegal program rather quickly, then if they decide they like the law, then it's not going to be that much of a delay. Sure is quicker to get through a paralegal program than to go to law school anyway.
Yeah.
And finally, the next slide just discusses this issue of supervision. And so bringing forward the supervision that happens for the students who are studying in law office or judges' chambers, and also this practical training for certified law students.
So the practical training, that was so I did that too while I was doing my law office study program. And that's every time I appeared in a case, my supervising attorney actually had to be in the courtroom with me. So it wasn't part of the educational process. It was just, if I had worked on a case, I got to go argue it. I actually did an argument in front of the Court of Appeal before I was an attorney, because we used the practical training part of it. So I don't think that that doesn't create a graduate status or anything like that. That's just how to deal with how many could do it. So you use this to show us the total number of people that an attorney could supervise? And
also just what's involved in the supervision. So if during the experiential training part, if we're going to talk about whatever 1,000 hours or however many hours, what should be involved? And should your subcommittee recommend some specifics about what's expected for the supervising attorney?
Right.
Well, I saw that what you had for the first year law students experience requirement. What is that called now? Off the top of my head, I can't think. The
6 units or
the practical training, or this,
yeah, PPLF.
Yeah, so there it looked like the supervising attorney had to have, was it 5 years or 4 years?
Well, this is this slideshow. It has to have practiced or taught law for at least 2 years.
Well, I guess what I was going to say, I find that interesting because in the Business and Profession Code requirements, for overseeing paralegals, it has to have been someone who's been practicing 3 years.
Okay.
Linda, was the purpose in giving us this slide, this was to help us with the experiential, not to look at an alternative way for someone to qualify?
Exactly.
Right, that's correct.
Okay, so looking at it for that purpose then, Julia, I'm with you. I don't know that I want to turn the experiential over to an attorney who's been practicing for 2 years. Do you?
No,
So we could take that from the law office study program, go 3 years, 4 years, 5 years?
well, I would say 3 years, but I mean, it was,
The law office study is 5 years. You think that's too high?
I'm okay with the 5. I always like to hear what Julia says before I put my voice out there, but
I would say, I'm not sure. I would say at least 3. I don't know that I'd go as high as 5, but I think at least 3. It should be at least the equivalent of who would have to be the one that was supervising the training of a paralegal, because, you know, not everybody goes to paralegal school, but we're allowing those who had a declaration of an attorney, et cetera, et cetera. So I guess I'm just modeling it after what I'm familiar with. So I haven't really contemplated. I think 5 years may be too much. I don't know.
I'm leaning towards the 5, just kind of thinking, I always attack this from a family law perspective, because I know that's one of the areas where we're going to see the most paraprofessionals. Knowing the attorneys that I've practiced against that have only been doing it 3 or 4 years, I would feel much more comfortable if the paraprofessionals would be monitored by someone who's got 5 years of experience. So I'm leaning towards the 5, Julia.
Do we have to decide today, folks?
No.
No, we can have we know it's somewhere between 3 to 5. I think we're both in agreement it shouldn't be 2.
Yeah.
Yep.
So the next 3 requirements for the practical training, I'm on board with.
Approve okay. So you want the supervising attorney to approve and sign all documents prepared for clients?
If they're going to actually be used in court or in a proceeding. In other words, if it's a mock, like we get somebody that's providing simulated experiential, like Linda was discussing earlier, of course, there's no real client, so those don't have to be approved. But if something that the paraprofessional experiential candidate is doing is going to find its way into a court file or become a final document, then obviously it would be the attorney that needs to sign off on that, not the candidate.
I agree.
That makes sense because it's prior to the person being licensed.
Yeah.
Correct. And that's exactly that's what happened is everything I did, I drafted it, but I wasn't the signer on it.
But it also supports the supervisory role that the attorney has to take responsibility for this person and the work they perform.
Yeah. So are you on, so I had all 3 of those. You're good with the 2nd, 3rd, and 4th requirements for supervising attorney from the practical training column?
Didn't they also have, where would isn't this where we would include that they would also have to be the one to sign a declaration?
I think that is, go to the column on the left from the law office study program. So the question is, how often would they sign the declaration? So that's exactly what would happen is my supervising attorney every 6 months had to sign off on my report that I submitted to the bar. I still remember the lady's name that I used to submit to. She's probably not there anymore, but.
Well, I think one declaration would be sufficient to say at the end that they've completed the practical training.
I would agree with that because it's a 6-month reporting period in the law office study program. And that's where I think we're headed towards the experiential. So I'm agreeing with that.
And what about this idea of providing the curriculum? Now, it's different than, there's no curriculum per se, but is there any desire to have any insight into what the practical experience is actually, what it actually comprises?
Well, I think we'd have to put the practical training has to be in the area, subject matter area for which the proposed paraprofessional is wanting to get licensure in. In other words, we wouldn't let somebody work for a real estate firm that wants to become a family law paraprofessional.
Exactly. And I think Arizona had a way of, okay, they called it endorsements. So they had the family law and civil endorsement, the criminal law endorsement, administrative law endorsement. So they had, that's how they described each subject matter.
And I wouldn't say that it has to be 100% of their experiential hours necessarily. What about Julia? So take my hypothetical. Let's say somebody, we're going to likely recommend an increase in the experiential hours. What if half of the experiential hours were in terms of preparing court documents, getting documents ready for clients, but was not in the endorsement area? Do you think like 50% of the experiential hours have to be in the endorsement area, 75%, 100%?
I want to take a little bit longer look at that by comparing the other states, because as I was preparing for today, I found a couple things very interesting about Washington. And this is a little bit off this topic, but I would like some time to look at Washington's program. And I don't know that Linda and Leah saw necessarily did Amos send you a copy of the email he sent to us about Washington and the fact that we were going, one of the big feedback was they wanted us to have more hours in the experiential portion. And then he followed up with an email and attached 2 documents to it. And I just looked at those documents last night. And it was a letter from the Supervisory Board of Washington to their state Supreme Court. And I decided I would like to take a look at that more before we talk about the actual content of curriculum and content of experiential. But at this point, I'm saying if they're going to be in the subject matter of family law, they've got to work at a family law attorney. Now, how does that exactly look? I don't know that we can say it's got to be 50% this, 50% that. The attorney's just going to sign off on it. I mean, if they've agreed to take on this responsibility, I don't know that you can micromanage that. I just don't know.
So Linda, did you get I'm not what Julie's referencing in terms, we got a different email from Amos that didn't include this letter. I don't know if I have that. That's neither here nor there, but it's
I
not
don't
ringing a bell with
think
me.
that I got that either.
So Julia, you're basically saying you're not sure that you want to further specify what the experiential, other than to say it's got to be in the area for which the candidate wants to be licensed. You're not sure you want to further specify what needs to happen as part of that experiential effort.
At this point, no. Maybe when we get closer in the subject matters and in identifying the exact scope of representation these folks are going to have, then we may be able to be more specific. But I think until we have the scope of actual tasks, I don't think we can necessarily speak to the scope of their training and experiential requirement.
And I don't disagree with it, Julia. My thought is maybe that's a requirement that comes through the subject matter subcommittees, because the amount of time necessary to do what we expect in family law will be much different than what we expect with the ancillary criminal tasks when they're just trying to clear records and stuff.
Yeah, I mean, we're going to have a total number of hours working in the subject matter in an attorney's office, et cetera, et cetera. I think for right now, let's just stick with that. And then, you know, as something maybe in parentheses to say, may revisit to see if it has to be more specific in terms of tasks that need to be completed while participating.
Got it.
The reason I said, Leah, that this letter I thought was very interesting is that because the letter that was written to their Supreme Court talked about the different community colleges that had put together curriculum and time into creating this curriculum for Washington. And I thought it was really a great way that if we could, because they're still, it's going to sunset, but they're in until 2023, I think it is. So if we went to the websites of any of those community colleges, I bet you we could see how they have their curriculum already rolled out in these community college, which would be helpful to us before we finalize our recommendations on curriculum.
Okay.
Got it. Okay.
All right. So do you guys want to revisit the experiential hours requirement now?
Please.
Sure.
Yeah. Do we have, Linda, or you all remember better than I, what was the proposal that went forward on October 29th on experiential? I can't remember.
In our memo we had, I think it was 480 spread out over 3 months.
Okay. And you're saying,
Can I interject something that I just also thought of, Linda? In that executive summary, I didn't catch it before, but when you summarize the program requirements at American River College, evidence is not a required course. So maybe you could revise that executive summary. We listed some of the required courses, and I think evidence was listed as if it were required, and I believe it's an elective.
Okay, I'll go back and look at the information that I got.
Okay.
At American River College, but in terms of revising it, I don't know, Brady, is it a problem to revise something that's already been posted and then replace it with a corrected version? And if I do that, do we need to, I guess it could be noted on the agenda item that it's corrected.
why don't you just correct it in the memo for the next meeting and indicate it? We'll just have a correction.
Okay.
Nunc pro tunc.
Okay.
I mean, if that's fine, I think that would be preferred. Generally, we've allowed corrections on the theory that it's substantial compliance is required, and we're still giving them the notice of the general topic area, and small changes aren't really violating the spirit of it, Bagley-Keene. But I think Leah's suggestion makes sense.
Okay. Great.
So from 480 to 1,000 is what you all are thinking?
Yeah, I think the folks had the impression, the rest of the working group, that it would be more experiential hours. And so we're happy to go to 1,000, I think. And in the end, once we revisit our curriculum, we may decide that more things can take place in the practical training than previously contemplated. So we may not need so much training in the classroom. So I'm thinking, you know, that's if that's what people envision for this is more practical training than additional academic training, then I'm happy to do that.
So you're saying that the experiential training that they get from in the paraprofessional program, not in the prerequisites, but in the course of the paraprofessional education, that would count towards the 1,000 hours.
Yes, the work that they're doing in their practical training, instead of it being 480, then it says over a minimum of 10 weeks to be completed, X period before, 1 year after, still within a time period like that, but we're going to double it to 1,000.
And there's 1,000 hours over 6 months. Because basically the 10 weeks worked out close to being 3 months.
Yeah.
Okay. And are you ready to make a recommendation for a modified classroom training, or that's pending?
Can you repeat that, Leah?
Are you ready to make a recommendation to reduce the sort of class direct instruction component? Or do you want to hold off on that?
I would like to hold off until I get a closer look at the curriculum, for example, in Washington.
Okay.
Agreed.
Right.
So the next meeting that we have scheduled is on the 30th. So for that meeting, you want us to get information about the curriculum at the community colleges in Washington?
Yes, and I'll forward you the email that we received from Amos.
Okay.
And we also have the number of California registered law school graduates every year,
Right.
and just clarifying who's able to, who offers an LLM program. One other thing I'd like to ask the two of you to consider is what incentives, if any, you think might be appropriate to kind of encourage attorneys to supervise. You know, I'm thinking about perhaps an MCLE incentive. That's the one I'm really thinking about. There could be like a licensing fee reduction, but I doubt that would go very far. But I think we do need to think about some kind of incentive, because I feel like it might be difficult for folks to find supervising attorneys. And we also may want to think about what role either the state bar, local bars, or other organizations might play in matching prospective paraprofessionals with supervising attorneys.
Yeah, I like the CLE idea. They're teaching, and we get credit for teaching hours towards our MCLE. Every time I teach a class, I get actually get a 4-to-1 ratio. I don't think we need to offer that, but I think that's a good idea.
Okay. All right. Do we have anything else for today?
Other than the public comment, I don't think so. Do you have anything else, Julia?
No, I do not. Not today. I'll forward Linda that letter.
All right, great.
Okay. So we can turn back to public comment. So again, if anyone is interested in making public comment, you can raise your hand using the icon. And the other, and if you're calling in, I think it's *9 on your phone that simulates the hand raising. So right now we have one speaker, that's Ira Spiro. So I'll go ahead and allow Ira to talk. Go ahead, Ira, you're, okay, there you go.
got it. Thanks. Hi, everybody. I on the statistics on the bar pass rate. Well, Leah and Linda, correct me if I'm wrong, but the way the bar, well, I have a question. No, let me make it a statement. The way I believe the bar makes us schools, meaning unaccredited and the Cal accredited, calculate our pass rate, it yields a much lower pass rate than other methods that I think are more fair and more reflective of what's actually going on. For instance, something I favor is you take the number of students, graduates, I should say, who do take the bar exam, and the percentage of those who pass within, say, 3 years. And that's much higher than the percentages you see, I think, on that you saw today, because those are based on the way the state bar does it, which is counts every individual instance of somebody taking the bar exam, even if they take it many times, and calculates the number, the percentage of those takings where the taker passes. That sound right to you, Linda and Leah?
Well, I think that in terms of the way that the data is analyzed, we asked Ron to do just this very straightforward analysis. We could ask that it be done a different way. I think that in terms of how that information would be used to inform the decisions by the subcommittee, it sounds like the data as presented was convincing to allow the registered unaccredited schools, the graduates, to participate.
I heard that. I was really happy to hear that from. But it does look striking when you first look at it, the difference between ABA and unaccredited, or ABA and Cal accredited. When you see those 15% numbers compared to much, 3 times that high. And it sure would be good to use a different method of calculating that. A method I think is fair. Anyway, that's my comment. We can talk about it. I sent you emails about it also.
Great, thank you.
Thanks.
The next person is Charlie Gilly. Go ahead.
Hey, thank you. So I'm a vice president at Neighborhood Legal Services of LA, and I'm an adjunct at Loyola. And I used to teach a class at UCLA called Lawyer-Client Relationship. I do commend that you guys are looking at the recent law grads. And that's good to see, and trying to figure out how we can utilize those individuals that have graduated from accredited schools. Another thing was, I was pleased to see that you may recommend supporting limiting the number of people that would be under supervision. I think to Leah's point about incentives, one way to sort of bring legal aid into the conversation as well is to think about structures where some of the supervision and the experiential hours could take place at a legal aid. Not that legal aid has the capacity to take all of it on, but having some sort of an incentive structure for legal aid, I think would be useful for everyone. One of the things I would encourage you to look at, and I know there's a lot to unpack in terms of how the experiential hours are used, is to ensure that the hours that they receive are connected to the kind of work that they may or may not be doing. And I think this is a tricky issue because it is potentially has to be looked at by each substantive area. But one of our concerns is that an individual would have those experiential hours in, let's say, in family law and certain types of tasks, but then when they're out on their own would be asked to go into a courtroom setting or into more complex matters and be out of their depth. And so I would, encourage you to think about when you we're breaking down the types of hours that they are prepared, and all types of hours that they would be expected to complete. So family laws, we're going to provide them with the scope of work for any sort of legal issue that they would be trained in that in advance. And I think, Julia kind of raised a good point about how, not micromanaging that, but I think that it is very important that we send prepared individuals into those, critical situations. But thank you for good discussion and for the public comment.
Thank you.
Thank
We don't have any additional public comment.
Julie and Stephen, do you mind if I ask Charlie a quick question?
No.
I'm just wondering how we might incentivize legal aid to do the supervision.
I'm still on. Okay, you can still hear me.
We can hear you.
That's a good question, Leah. I think that's something that we can come back with a more concrete proposal. I don't want to speak on behalf of my colleagues, but I think that that's a good topic for maybe a future meeting, and I'd be happy to come back with something more concrete.
Okay.
Because I haven't really thought that through completely.
All right. Thank you.
Thank you.
I don't think we have any other comment. If anything else that Julia or Stephen, do you want to say before we end the meeting?
No.
Great. Thank you very much. We end a little bit early. Appreciate
Thank
it.
you.
Take care.
Thank
everybody.
you.
Bye.